petition of the Public Service Board. And really what we wanted is to have women's listing on the same line at no additional cost. And I'm just going to summarize what the hearing officer said. One witness, the mother of school-aged children, had difficulty contacting their married female teachers. Another, an attorney, has had difficulty discovering the telephone numbers of married women needed as witnesses in legal proceedings. Two witnesses had difficulty contacting married women as potential supporters and volunteer workers in connection with political campaigns. And two legislators had had difficulty contacting married female constituents. The response to this, which was also summarized by the hearing officer, was that the current way things were done was reasonable and adequate. And if people wanted to have, if married women wanted to have another listing, they could pay 75 cents extra per month for the second line. And so this is the summary. The conversion to a joint listing format, if it were offered as part of the basic service and widely accepted, would require the telephone company to do several things. The new policy would have to be announced. Tens of thousands of orders for joint listings would have to be received and processed, and the actual listings would have to be changed and published. The joint listing format would result in an ongoing burden for the company to the extent that its employees would have to spend additional time with subscribers when taking orders for service to determine whether a second given name should be listed in the directory. The joint listing format would increase the search time required for directory assistance operators in that they would be basing more searches on non-alphabetical clues, the given names of spouses appearing second in the directory listing. This increase would be offset and perhaps overcome altogether because joint listings would readily identify far more subscribers. So that was the argument. And we filed this on March 15th, 1974. We got a decision from the hearing officer on January 7th, 1976. And the hearing officer did say that the benefits of residential directory listings accrue to the public generally as directory users more than to the particular subscriber who is listed. It is therefore doubtful that joint listings would be widely accepted or their advantages fully realized if they were offered as service options. However, if the joint listing format were offered without the imposition of special charges, that is, if the extra costs were assessed to all subscribers, the services would be widely used. So that was a very, and then they go on to say the evidence and arguments that have been presented reveal the public benefit of a joint listing policy, and it would provide, without imposition of special charges, would be substantial. The addition of these thousands of names to telephone directories would greatly enhance their value, and that is the underlying service. The present failure to publish these names makes existing directories somewhat incomplete and inadequate. So, to conclude, this decision that was rendered by the hearing examiner on January 7, 1976, almost 2 years after several sets of hearings, the loss of transcripts, the recreation of the transcripts, was that he thought we should do a pilot project. And one of the 9 directories to see what the costs might be. If you think that's not bad enough, in September of 1976, a full 8 months after the decision was rendered, the hearing officer's decision, they dismissed the petition. They dismissed the petition. And they said that that the tariff that was filed by the telephone company was adequate. And they said it finds that as a matter of social policy, it would make sense to list all users of a telephone in the telephone directory, but it's not illegal or unreasonable to permit only one listing as part of basic residential service. So there we are, 2.5 years after filing this petition, we had a dismissal. And there was a concurring opinion issued by Martin Miller, who was then the chair of the Public Service Board. And it's interesting to read 38 years later. So I'm going to quote that too. It is widely reported, this is his quote, "It is widely reported that women are becoming a more significant part of the workforce. That fact alone, in most families, may, quote, require, end quote, a listing of both the husband's and wife's names. I believe that the telephone company's policy of providing, quote, such information as is essential to the identification, end quote, of a subscriber has served the public well in the past. But I question its usefulness in the future, so long as the telephone company narrowly defines, quote, subscriber, end quote. So then he goes on to say that there weren't any elasticity studies done to determine the cost. So there we have it. So the women who I worked with, Phoebe Morse from the Attorney General's office, and a number of prominent women who are witnesses, including the Governor's Commission on the Status of Women and others who, those of you who've been in this battle for a long time will remember, we appealed it. And our appeal was filed probably in November of 1976, and then in March 1977, we withdrew the appeal because the telephone company agreed to provide the joint listing and the telephone book. So every time you look for a husband and wife with the same surname, which my husband and I did this morning, and you find Skinner, Scott and Mary, it was the result of this litigation, but it was also the result of settlement when it was clear that Martin Miller really thought, who was then the chair of the board, thought that we ought to have that as a way to find people in the telephone book. So that's my story.
How many of you knew that women weren't listed, right? That's how many of you never had heard that before, right? That's why we need to know our history, right? So our next speaker is Sandy Baird. Sandy is also among the first 100 women lawyers in Vermont and on the faculty at Vermont College, and has done a significant amount of work on progressing women's rights here in Vermont. So Sandy?
And I think we need the microphone, am I right?
Yeah. As Cheryl said, I'm Sandy Baird, and I had the pleasure of working with Mary Jess Skinner for many years at Vermont Legal Aid, and I chose an alternate path to go to law school. And I think that alternate path, not to go to law school, excuse me, I was a clerk at Vermont Legal Aid for 4 years, and then at that time and now, women and men can take the bar and become lawyers if they pass the bar. And then they're admitted to the bar and they serve, as all other lawyers do, to represent people in our courts and to be, in fact, attorneys. I would mention that because at the time I was a low-income person, and it made more sense for me to do it that way. I had 2 little kids. I didn't have much money, and to clerk at Vermont Legal Aid was the best way that I could become a lawyer and the cheapest. And I would remind women and men that that still is the case, and we can still do it. So that was the first way that was the way many lawyers became lawyers at the time, and they still do, including one of our justices on the Vermont Supreme Court. Okay, but one of the earliest events that I was involved in as a paralegal at Vermont Legal Aid, I was the paralegal who did all the divorce work, who took all the calls, who made all the referrals, who prepared the legal cases for court. And then I would hand over the case to the attorney, which made me want to be an attorney, by the way. I wanted to go to court and handle my own cases. However, I was a paralegal, and I noticed that we had particular problems in Burlington and all over Vermont, and probably all over the world, of violence against women. And that was the time when there was no civil procedure to deal with violence against women. The only thing a woman could do, and by the way, I know that there are male victims of violence also. I'm very aware of that, but as I tell people, 95 to 98% of victims of violence in the home are in fact women. And regardless of whether they fight or whether they argue or whether they're giving their husbands a hard time, it generally amounts to the fact, in the end, that the man is more physically strong than the woman and is therefore mainly the perpetrator of violence against their spouses. At that time, however, all women could do, or any victim of violence in the home, was to call the police. It was a criminal proceeding. I remind you that it still is a criminal proceeding, but we now have a civil proceeding to deal with it. And it was very difficult to get women to call the police, as you might guess. Some of the women didn't simply want their husbands arrested, and many of us would not want a husband arrested, even though we wanted to stop, or also a partner who lived in the home with you. So at that time, and also many women were then and now dependent on their spouses for money and for ways to support themselves and their children. And they didn't really want a permanent arrest record for their partners, and they didn't want to permanently kick them out of the house. But at that time, we devised what is now called the Relief from Abuse procedure. And that is a civil procedure that women or the victims of violence can call a hotline at any time of the day or night and request a temporary relief from abuse order, which is in the civil court. And that can be granted ex parte or from one side of the story, and that person can be removed for at least 10 days. At the end of that time, then there is a full-blown hearing of the two parties where the offending party can come and deny the charges and get back into the home. However, this is like a cooling off period that is very helpful, I think, for victims of violence not to proceed to a criminal proceeding and not to proceed to something that might force somebody to be in jail with a jail term and also with a prison record. So this was the result of all that struggle. A number of women got together at that time and crafted a relief from abuse order civil procedure that now allows women and victims of violence to call a hotline or to proceed to court and file an affidavit and request a temporary restraining order that virtually takes the offending person out of the house for a period of 10 days without the permanent kind of decision-making of a divorce or a criminal proceeding. And that's basically what I was early involved in. I've been involved in other women's rights struggles, including I was the first Vermont woman, as far as I know, to change my name back to my maiden name while I was married. And while I was married and went to the probate court with this male judge, I was told, you better get your husband in here and have him give permission for doing such a radical. And thank you all for being here, and thank you for asking me to speak.
Katie, what did you say to the judge when you told you to get permission?
Of course, I said,
So our next speaker is Justice Denise Johnson, and I know many of you know Justice Johnson as the first woman to the Vermont Supreme Court, appointed by the first woman governor of the state of Vermont. I have often said of Justice Johnson that she was our court's first feminist. I'm not sure if I did.
I love it.
Oh, good. And that having her on the court made significant difference in how Vermont law became interpreted. But she is going to talk about her work before she came on the court, so I'm very excited to hear that.
Thank you, Cheryl. Well, I'm really pleased to be here, and it's kind of fun to take this. It sounds like we're going back in time from Mary's story and Sandy's story. So I'm going to go back to 1980 when I first went to work in the Vermont Attorney General's office. I had a lot bigger hair. And I was the chief of a division, it was called the Civil Rights Division then, that enforced the Fair Employment Practices Act, which is not nearly as specific as it is now. If you look at that booklet that the Governor's Commission sponsors, which is a wonderful booklet, by the way, you can see all the specific employment protections there are now. But back then, 30 years ago, it was just, you couldn't discriminate against someone in employment on the basis of sex and a whole bunch of other categories. But because of our demographics back then, almost all of our cases were sex discrimination. There are two areas of gender discrimination where I felt like we made an impact. And the first was in pay equity. This was the era of comparable work. I don't know if everybody remembers that term. But that was a because of the problem that Cheryl referred to called the pink and blue shop. So the men were in the blue part of the factory, and of course they had higher wages, and the women were in the pink part. And so the pay gap between men and women at that time was women made 59 cents on the dollar. I think the average now is about 77 cents. But 59 cents on the dollar is not very much. And all sorts of people, including the National Academy for Sciences, have studied this problem and concluded that you couldn't explain this gap between 59 cents and the dollar by other than discriminatory factors. In fact, it showed that when women moved into a sector of the workforce in substantial numbers, the pay went down. Because it followed the status of women in society rather than the evaluation of the job. So it was really hard to attack women's pay because all we had was intentional discrimination. And this discrimination had become so institutionalized against women that it was hard for a woman to say, well, this supervisor hired me at the wrong pay, because this was what women had always been paid at this plant. So that's where comparable worth came in. And under the comparable worth theory, women argued that employers should look at the jobs that women and men were actually doing and evaluate them from the standpoint of whether they were equal in skill, responsibility, and effort, rather than I'm a secretary so I get this much and this man is a clerk so he gets more. So we had a case that presented itself to us in Brattleboro. It was women complained that they'd been working at book press and they were using big binding machines to bind books. But this was a classic pink and blue shop. The women made maybe more than $2 less than men per hour. And so my colleague and I, Susan Sussman, who's already been mentioned today, we sued book press, alleging that the male and female jobs were substantially equal but paid unequally. So in a preliminary hearing, Susan secured an attachment of $750,000 against the book press assets. And after that, they settled. It was a great result for the women, but we didn't get our theory up to the Supreme Court, which is what we would have wanted. So taking a little bit different approach to pay, at that time, I was also working on the advisory committee to the Governor's Commission on Women. And they decided to undertake a series of statewide hearings to really understand the status of women in Vermont from a whole bunch of different standpoints. And I was working on economics, and we had the great good fortune of having Barbara Snelling, who at that time was the governor's wife, chair this committee. And Barbara really took this work very seriously. And in the economics committee, people were really concerned about, well, we've got to get women to work, we've got to get women to work. But my argument was, well, you can get them to work, but if they can't pay their daycare and they can't pay their transportation, what good is it? We really need to work on pay. And one of the things we accomplished is that we got the first we got the governor to agree, of course we had his ear. We got the governor to agree to undertake the first comparable worth study in state government, where women's and men's jobs as classes were compared on the basis of effort, skill, and responsibility, and not just the fact that this was a secretary and that's what secretaries were paid, and so on. And that was called the Willis study, and it continued after that. There's another area in which we, I think, made a big impact, and that was we established a cause of action for sexual harassment. And we did that through litigation. Now the law is very specific about sexual harassment, but then again it was just sex discrimination. And we had a case in which a night supervisor at a cable company was supervising several women, and he would stand and stare at them stand, right? They were running big machines. They were running wire through their hands to see if there were burrs on the wire. So you can imagine this big machine and wire running through your hand. This guy is right behind you. Or he'd stand in a place where only the operator could see him and nobody else could see him. And this kind of behavior never touched him. But this kind of behavior went on for months. And the women who worked there who complained were emotional wrecks. I just want to recognize Robert Appel, who was the investigator who worked with me in the trial of that case and who unearthed a critical piece of evidence at the company that we used to really nail them. And that was because he was very diligent about the discovery process. So how are we going to prove this? He never touched them. First, we had to show that sex discrimination included sexual harassment. This was not established. That being singled out for this kind of scrutiny just because you were a woman was discrimination. And second, because these women never lost any job benefits. Their pay wasn't altered or anything like that. We had to show that the emotional distress damages that they, or injury that they suffered should be compensable in damages. And that it wasn't, the act just wasn't about back pay, it said damages, and damages meant damages for this kind of emotional distress. And we won, fortunately, both of those points with the trial judge who issued a very lengthy opinion. And although the case was not appealed on the merits, it became the standard for other cases in Vermont. For us in the AG's office, we were able to bring other cases. It was as good as the Supreme Court opinion. And so that was very good. Now, as I said, there's a lot more specificity in the law, and employers have an affirmative obligation to educate people about sexual harassment and to be much more proactive than they were then. So that's my story. That covers a sort of 1980 to 1988, and now it seems like really old news.
My mother was in a pink ghetto job, and she was sexually harassed all the time as a single woman in those jobs. And there was nothing, she was, there was very little help available, so thank you for that work. Our final speaker today is Peg Flory. Many of you know Peg for her many years of service in the Vermont legislature. You know her as a lawyer, and she's going to also talk about her path to the law and the work that she's done. Peg?
Thank you. I'm sitting here listening and realize what a newcomer I am to this. I took a very different path. Grew up in the 50s and 60s, and when I graduated from high school, unless you were one of the two brightest or the three richest, if you said you were interested in law, they said, then be a legal secretary. That's the way it was, so I did it. I became a legal secretary, I became bankruptcy clerk for the state of Vermont, and then I started having children and made the decision to stay home with my children. Had 3 boys. Brings a new perspective to issues. I was raised an only child, and I guess my view on gender issues was instilled by my dad. Dad was my entire life a janitor. We had no money. My mom babysat for kids occasionally. And my dad ignored gender. My dad wouldn't let me get a license until I could prove to him that I could change a tire on the car, which helped me a month ago when I had a Now, I will say I'm also wily enough if there's an able-bodied male around, I can play helpless. But I was able to change the tire. He taught me that I could do anything I wanted to, and that gender didn't help me or hinder me. And that's what I tried to do with my kids. My sons are all married with their own kids. 2 of them are the cooks in their house and their wives mow the lawn. 2 of them are the ones in charge of daycare for their children. That I like. But I continued to work part-time as a legal secretary while my kids were growing up. I was the den mother, the PTO, all of this stuff. And they got to a point that I realized they were going to be gone, and I was going to have a big empty nest problem. So I went back to work as a full-time as a legal secretary when my youngest was 6, and got really interested in it. And I hit 40 and decided it was time to figure out what to do when I grew up. And just happily at that time, Champlain College had their first ever paralegal program. And so I signed up for it with the idea that, gee, this 4-year clerkship sounds really, really good. But you need to have 3/4 of a bachelor's degree in order to do it. I had an associate's. So I went back 2 nights a week for 3 years to get the second associate's, bumped all of those into a bachelor's, or 3/4 of a bachelor, and started the 4-year clerkship. Did that, passed the bar exam, found out I had passed the bar exam the same week I found out I was going to be a grandmother for the first time. Wasn't sure which was more exciting. Still not sure which was more exciting. At about that same time when I was finishing my clerkship, I ran for the Board of Selectmen in my town because I got annoyed at some things that were going on in my town. And while I was there, I got annoyed at some of the things the state was doing in my town. And some of the lectures I had given my sons came back to haunt me when my middle son looked at me and said, "Mom, I'm going to tell you what you used to tell me. You don't have a right to bitch about the problem unless you're willing to be part of the solution."
Good boy.
I said, okay. And I ran for the House and got elected. This is currently my 14th year, 11 in the House, and this is my 3rd year in the Senate. I continue to have a law practice. It's quite a bit of juggling. I do primarily family law, which is the area I said when I was clerking that I'd starve before I ever did family law. Took my first case and got hooked. So I can, probably about 70% of my practice is family law. I've been fortunate in the legislature. I chaired House Judiciary for 4 years and served on it for another 4 or 5. Also served on judicial rules, chaired judicial nominating, and a variety of other issues. And I really struggled when they said this was on women's issues. Because from my perspective, we've reached the point that I don't know what women's issues are. And I refuse to say anything is a woman's issue. There are issues we need to work on for all of us. Bill Lippert can tell the number of times in committee that someone would say violence against women. And I'd say we're past that. It's violence against people, and we need to keep pushing it. As soon as we would talk about anything, a woman's issue being childcare, no. Don't make that my issue. Dads should be every bit as responsible as moms should be. Now, I'm also practical. I realize there's an awful lot of moms out there with kids that dads aren't willing to help out. What I've contributed, I don't have a clue. I've worked hard on the restitution fund, capitalizing the restitution fund we did a number of years ago. Women take advantage of that, so do men. We worked hard on rewriting the Chapter 55, which is the DCF thing to protect children. Both moms and dads are involved in that, and it protects both of them. Spousal shares in intestate estates. I carried that bill, which became a very personal issue after reporting it, got off the floor and found my husband had died of a massive heart attack. That's brought in some new issues to me as I face life as a single person, which are both women and men issues, but probably a little harder for us. And unlike Mary, I'm getting Social Security and loving it.
Think about Jessie LaFontaine Bigwood, who many of you may not know was the very first woman lawyer in Vermont. And if you ever drive through South Royalton, the highway marker is at the law school. But for so many of the early women lawyers in the state, the only path to the law was by reading for the bar, by avoiding law school. And many of those women were actually their husbands, had husbands who were lawyers, and then they were their secretaries, paralegals, and then ultimately became lawyers. So that's just a great story. Thank you, Peg. We have plenty of time for some questions, and I know you must have questions or comments, so please raise your hand. I'll call on you. Maybe I can ask you to speak loudly. In the blue, yes. If you just wouldn't mind standing, thank you.
I want to thank all of you for everything you've done, and having also worked at Legal Aid, I just want to make sure people know that what Mary and Sandy talked about were just barely scratches on the surface of all the incredible work they did. And I'm curious from both Mary and Sandy's perspective what it was like to break through with some of the first women lawyers in Vermont to the sort of old boy network, not only male lawyers but male judges as well.
Frankly, I never honestly noticed the difference. I think that women lawyers were treated fairly in the law. However, I always noticed that within the law, there are problems from all the judges around poor people. And that is something that I always was aware of, because there are problems with poor people getting attorneys, problems with poor people getting a fair shake, about their rights and attitudes toward them. So I never particularly saw gender bias in terms of women attorneys, but I have seen, because most poor people still are women, or many poor people are women, I have seen problems in the court, particularly about low-income women.
I think I'd agree with Sandy, because if you remember, I was admitted in 1972, and there were only 43 women, 42 other women that were practicing, so you were often the only woman there, and I agree in some ways that it was the discrimination against poor people, because there used to be a story that someone told me that I was accused of wearing blue jeans to court, and I could never figure out whether it's because I worked for Legal Aid, and I never did. I never wore blue jeans to court. And I could never decide whether it's because I was a woman, whether it was because I worked for legal services, or whether it was because I was representing poor people. And that was not the judges, that was the other lawyers. I found the other lawyers were more difficult than the court personnel in any way. I mean, sometimes it was like in the days of law school where your compatriots would tell you that you were only going there to get a husband. I mean, as if you were spending your hard-earned money to get a profession because you wanted to marry these people. It's crazy. But that's kind of what I wanted to get into it when she asked us, where do we go from here? I think we need to remember our women's history. I think other groups that have been discriminated in the past, either African Americans or Jews or Romans or whatever, know their history more. And I was having this discussion with Madeline last night, and in a way we don't remember these things things. I mean, I looked at this telephone case last night, and I completely forgot that the case had been dismissed because we won the issue. But it was 2.5 years getting to that point. And so the bottom line is that we need to know our history, and we need to know where we've come from so we can go forward into the future. And so my one last story, because I know Cheryl wants it back. It was Justice Gibson, who first recommended that I run for office. And I was a senator in Washington County for 14 years, and the first of a number of chairs of committees. And that was what the judges did. He was one person who said, have you ever thought of doing that? And frankly, I never had until he said that.
I just want to touch on that a little, and it's funny, I don't know that it's a gender bias as much as a position bias, the poor or needy or positions. What absolutely shocked me is I worked in the legal field as a secretary, as a paralegal for a long time. Other attorneys were, a lot of them, rude, dismissive, wouldn't listen. The day I passed the bar exam, all of a sudden I got a brain. And I, for the life of me, couldn't figure out, I don't think 2 weeks earlier I was any smarter than I was once I got admitted. But all of a sudden, folks would talk to me that before that wouldn't. And that really irked me. I worked as a secretary long enough that I know if anyone's going to get anything done in an office, you better be friends with that secretary, and you better depend on that secretary. Otherwise, the work doesn't get done. But it seems professionals tend to discount the work that the support service does. And boy, that irritated me, and it still does. And every time now I catch it happening, I let them have it, both barrels.
Well, I don't want to forget that the court did a gender bias study, which was completed by the time I was appointed in 1990 and documented a lot of gender bias, some of it from male attorneys to women attorneys, disrespectful language in court. I know I had one adversary who used to always figure out some other way to refer to me in court, and it would be because I had taught at Vermont Law School. Sometimes he called me the professor, and another time he'd say little lady or whatever, something that called attention to me in a way that was not, he didn't mean in a totally respectful way. And one of the things I remember is that judges just couldn't remember who you were. All women were, the same. They couldn't remember your name. And even in another state when I worked for legal aid, I was always that woman from legal aid. So there was a certain non-recognition that went on, and one of the things we did in the court system is we undertook training for judges, and our judges responded really well and were careful to, the most important role they could play was to stop what was going on in the courtroom if another lawyer was being disrespectful to a woman on the basis of gender. So it was there, some of it was subtle, but it's definitely there.
That reminds me of a story that I heard Sandy O'Connor talk about once, because she would say once Ruth Bader Ginsburg joined her on the court, the litigants always mix them up, right? And they would always get them confused. And you're talking about the United States Supreme Court, where, those lawyers are making way more than anything this room is, right? And so they got T-shirts made that said, "I'm Ruth." So, people did with Maryland, Justice Scalia and Justice Johnson as well. Did you ever get shirts made? No. Next appointment. Next appointment. Sarah?
Well, first I want to thank you all very much for not only only being here today, but also for the tremendous work you've done in trailblazing. I'm a beneficiary of much of your work. I'm a recent graduate of the law school and also a new legislator. So thank you for all the work that you and many in the room have done. What I'm interested in knowing is if you feel that women, or if you could shed some perspective on whether women have impacted the way that the legal system approaches dispute resolution, both in family law, perhaps in other areas of law, but I have a sense that you've impacted the way that the system approaches these resolutions, and I'd like to know some of your stories and how that's changed through time.
I think it has, and I keep, I go back to the equality is not the same as sameness. Everybody's equal, but thank God we're not the same. And women approach resolution differently than men, and I think it's changing, but women we're used to compromising. We've had to do it, we've had to multitask for a long time. I think the mediation, the stress, at least in family court, on pretrial mediations, on case manager conferences, that has helped a whole lot. And I think the judges and the case managers are becoming much more assertive, particularly where there's children involved, in reminding both mom and dad that, hey, whatever you do is going to impact these kids forever. And we get I lecture my clients, we get into a courtroom and start throwing the nasties at one another. How are you going to feel having to face this person for the rest of your children's lives? Because just because you hate one another, you're still going to be at these kids' weddings and all of that the rest of their lives. And I think now that women feel a little bit more empowered and are a little more empowered, they've taken the lead role in insisting, in calming the situation down and insisting on trying for the mediated resolution. Although, I'll tell you, I've had both men and women that just get stuck and forget it. I love it when I get appointed by the courts, which I do quite often, to be attorney for the kids. So I go tell them, both parents, hey, you're just not going to do this to these kids. I don't care what you want. I don't care you hate one another. Assuming there's no violence, because that puts a different spin on it. But I think it has made a difference.
I would say that it's a lot of the, I was trying to think of a personal example and I really couldn't think of one, but I think having women on the court and having women legislators who have, and sympathetic male legislators, Bill, Judiciary Committee, who've really understood that it shouldn't be as confrontational as it is and have put in place steps along the way where you can have conversations, has really made it so it doesn't have to be as bad as it was. And so, I can't think personally of a litigated case where it was really awful for me, and that's why I spent a lot of time up here. But I think it's the women on the court, the women in the legislature, and sympathetic women who come together and try to make it a less adversarial thing. And of course, the collaborative law process too has a lot of adherence too, and that's helping in quite a number of different ways. So, Sarah, it's nice to meet you.
Yeah, not to dump rain on the parade of mediation. I deal with cases most often that have violence involved. In that situation, mediation is very tough. And I would say that we, in general, need judges to solve those cases. And the parties need to be separated. And I would really emphasize that because of short court time, and because, for instance, in the family court, the courts are now shut down because of costs, numbers of times a month, I think that it would be rather good to have more judges, those judges to be sympathetic and to be with us when we go for those cases that simply can't be resolved because of violence in particular. On Thursday mornings when you have relief from abuse hearings in court, it's just too tough to put two people in the same room with a mediator when there has been violence involved.
So we just have another minute or so left, and I had asked each of our panelists to give some thought to this question. I just asked them to each briefly respond before we say goodbye. I think for many of us who've looked at this book and who've done work in this area, we think, gosh, look at how much we've done. It almost seems like there's no area of either work or no area of law where women don't have some parity with men at some level. And so we say, well, what's left to be done? What's left to be done? And so I'll ask each of you very briefly, what's left to be done?
Well, there's a couple things I would say. First of all, as the recent political discussion has shown, we can't feel complacent about reproductive rights. And I'm left wondering whether we're going to have to go back and fight old battles. So I think we have to be eternally vigilant and not complacent about things we've won. And the other thing I would say is we need more women lawyers, we need more women legislators, we need more women judges. I think nationwide, if you take into account the federal courts and the state courts, women are still less than a third. That's not very much, and I don't know what the statistics are on legislators, maybe Peg does, but
38%.
okay, we need more women.
I totally agree with Justice Johnson, especially about the struggle for reproductive rights. Many of the women in this room were involved in that early struggle, as I was, and I think it's an incredibly important struggle, and that it is ongoing, and that we can see it right now, of course, in the presidential race. But secondly, I would urge more education, particularly of attitudes of young children. Remember, I'm the person who sees so much violence against women. That's not only in the home, it's on the streets, it's in sexual assault, it's in all kinds of cases that still involve women, and there hasn't been much of a decrease in those kinds of crimes. Somehow attitudes have to be addressed, and I think that is largely education. I think the law, as far as I can tell, is fairly fair toward women, but attitudes still persist that really need in some way to be shaped in order to treat women with respect and with the dignity that they deserve.
I would agree. I think one of the things that's left undone, or not done as well as it should be, is teaching women how to advocate for themselves, to stand up for their rights, to not expect someone else to do it for them. Teach women and teach men what equality is all about, and give them, the women particularly, the encouragement to be able to go and advocate for themselves, stand up for themselves, give them the tools of who to go to when they need assistance. I think the law so far has done a pretty good job on bringing about the equality that we're all looking for. Now we just need to teach everybody what it is.
I'm going to reiterate what Justice Johnson and Sandy Baird said, that I think the most important areas for us to go in is knowing your history, protecting and be prepared to fight for the battles that you thought you had won. I think reproductive rights, contraception, abortion, the Sandra Fluke and Russ Limbaugh stuff is just astonishing. And the Planned Parenthood stuff, I mean, really. And I fear that the generation of my children doesn't know some of those battles. And I think it's our job to make sure they understand how hard the battle was, and to make sure that those of us who were there are there again, and that the younger generation joins in so that we are protecting the issues we won on. And then the second thing I think we need to do is, it's kind of just a little bit variation, is I think we need to be politically active. And that can take anything from Democratic, Republican politics, being active in your school, but I think we as women have to stand up and start getting counted a little bit more. And really stand, go to the new frontiers, because there are other issues that we should be addressing. And when I was talking to Madeline not too long ago, she's got a new book coming out about new agendas, and she's talking about protecting working families, and we need to go places where we've got paid maternity leave, we need to have paid family leave, we need to have all of those things, and workplace flexibility. I mean, those are the issues we should be going to, and those are the issues that you, who are legislators, will I hope be working on, but it's amazing that we have to go back and fight the reproductive, contraceptive, abortion issues we fought in the 70s. It's astonishing. We have to be vigilant.
I would like to just say one thing before we quit. I'm Marcia Merrill, Chair of the Commission on Women. I thank you all for coming today. It's been wonderful. I too worry a great deal about the steps backwards that it feels that have been happening in the last 5 to 10 years. I remember that struggle in the 60s and the 70s, and I still, my worry is these accomplishments that we've made in the law are just law, and that we still are not protected in the Constitution of this United States, and that we, I believe, need the Equal Rights Amendment in order for these rights to be protected in a much more stringent way. Thank you.
Very interesting. Thank you so much. I just wanted to thank my friends at the Vermont Women's Commission for helping to put this on, and especially Janet Bullard and Lily Talbert, who say, please take some dessert home with you. Also, I want to thank Jeff Thompson from Action Circles for running over here with a camera, so we actually have this recorded, and we can let you know where that ends up. That's right. You're on record now. And also, I just wanted to point out that the Vermont Historical Society, we have a display over here. And if you want to know any more about programs that we do that are really as enlightening as this one today, please, check it out, sign up for email, learn more about us. And lastly, thank you so much, everybody. You are women of history.